financial problems, elder law, tax problems, business matters, divorce, personal injury, bankruptcy, your life, your reality. Life is complicated. There is the law and there is reality. Welcome to Law and Reality, sponsored by Thav Gross. Now here's your host, Ken Gross.
Hi, welcome to this segment of Law and Reality. This segment, I want to talk about something that we've talked about on the show many times, but I really want to dig in deep on one narrow issue to really flesh it out, because I have Brian Small, who I call the Wizard of Bankruptcy, with me today, my co-host. Good morning, Brian.
Good morning, Ken. Wonderful to be here.
All right. Well, I want to talk about how we use Chapter 7 in ways that most bankruptcies don't know about. The issue is surprising long-term benefits that we can get out of a Chapter 7 that most people don't think about or realize when they hear about bankruptcy. You game for that?
Absolutely.
Right.
Bring it on.
The starting point is the house. And people don't, you have to, first of all, it's not the house itself, but it's your obligation to make the payments on the mortgage. And how we can use Chapter 7 to keep a house that's underwater, but to get rid of the obligation to pay so you can keep it as long as you want and then get rid of it. But I really want to flush that out, and I want to start at the very beginning. People need to understand the role of a mortgage and the role of a note. When you go to the bank and you borrow $200,000 to buy your home, and you pay $210,000 for the home, people commonly think, well, I took out a mortgage. But in fact, they did two things.
That's right.
They gave a mortgage on the property,
which is the document that provides the lender with the security interest in the home itself, the physical bricks and mortar.
It's a lien.
That becomes a lien on the house. That's what a mortgage is.
And in it, so the mortgage is the lien. The other document, which is the important one, is the promissory note, sometimes also called the mortgage note. That is, I promise to pay. And if it's a husband and wife, it's we promise to pay, because both of them would sign. And that's the monetary obligation to repay the debt. That's a separate concept from the mortgage. The way the mortgage works is the mortgage says if you default on the promissory note, then under the terms of the mortgage, the lender has the right to foreclose the home, which means to force its sale, take the proceeds of the sale, and apply it against the note obligation, the monetary obligation. And you can foreclose two ways. You can foreclose by advertisement in Michigan, which we call a non-judicial foreclosure, and you can foreclose judicially. Now, a non-judicial foreclosure in Michigan is the common way that it occurs. Once the default has occurred and the lender has accelerated the full balance on the loan, they can publish in the legal news they're only required 4 weeks, but they normally do 5. And then they say your house is going to go to auction sale on that date. And if you don't stop it, it goes to sale on that date and it's foreclosed. And at that point, you have 6 months to redeem the property by paying the amount that was paid for at the foreclosure sale, which is normally bid by the lender because they're the only one that shows up to the sale to bid. And they could bid the full amount of the debt, or they could bid less than the amount of the debt. Their obligation is to bid the fair market value of the property.
And where you saw some real huge problems with that was, say, 4 or 5 years ago in Detroit, where your property once was worth $150,000 and now is worth $15,000.
So the lender bids $15,000.
The lender bids $15,000, and you had a $115,000 mortgage.
The deficiency would be?
You still owe the $100,000 deficiency to the lender. But here's an interesting thing about all this foreclosure stuff that the lender's going to do or could do. They don't have to. they can just choose to sue on the promissory note all by itself. They can forego attempting to collect against the house.
They can just release. They don't have to bother with the house.
That's right.
If it's not worth any money.
And so what we've seen is a lot of people that thought that they just walked away from their house and the lender never foreclosed, but they're getting sued left and right now on the money that they owed the lender. And it doesn't go away. And the lenders in Michigan have up to 10 years, depending on the type of information in the mortgage, to sue on the promissory note.
So go all the way back to the beginning of the financial crisis, 2008. That still takes you all the way to 2018 before you're free and clear. And if you walked away in 2010, you've got exposure to 2020. And we're seeing those exposures come through. Now, so that's the framework of the mortgage and the note. And why it's important is you have to understand, if you file bankruptcy, what it does with regard to your obligations as opposed to the mortgage, in contrast to the note.
Yeah,
so
what
Brian,
it does and
explain
what
that.
it doesn't do.
Yeah.
What does it do? The filing of a Chapter 7 bankruptcy, should you qualify for that, eliminates your personal responsibility to pay the underlying note. It's very
What about the mortgage?
The mortgage
Isn't that the
exists on
same-
the property.
Isn't that the same thing?
No, and here I'll give you a great example of how you can tell the difference.
Well, you could have listened to the first 3 minutes of the show today.
Right, again, but great Aunt Sally
Sally.
just dropped dead, and she left you her house in Bloomfield Hills worth $400,000.
Okay.
She's a great aunt, isn't she?
Is it free and clear?
No, unfortunately, it has a $400,000 mortgage on it. My
she
question:
was a sweet great
Yes.
aunt, but she wasn't a great aunt.
do you have a legal obligation to pay that bill?
Absolutely not.
But you want to keep the house. What has to happen?
I have to make the payments or they'll foreclose.
Okay, that's what happens in bankruptcy. You eliminate your legal obligation.
I become Aunt Sally?
No, Aunt Sally's in a pine box. You eliminate the personal responsibility to pay the debt. It becomes almost as if you've inherited the property.
But
If
you
wanna-
don't get rid of the lien.
You don't get
mortgage.
rid of the lien. If you want to keep the house under Chapter 7, you have to pay for the house. But you don't have to re-obligate yourself on the note in order to retain the house. You just have to keep paying the mortgage.
All right, so that means at that point, I still own the house. I have gotten rid of the obligation to pay the mortgage, but if I want to continue to live in the house, I continue to make the mortgage payment.
Now,
correct?
our listeners are probably sitting there saying, why is that important? So let's point out why it's important. Let's assume the house is worth $100,000.
No, let's assume the house
This is worth $75,000, and you owe $80,000 on a first mortgage and $30,000 on a second mortgage.
I like that assumption.
What are your options? Well, if you've discharged your note responsibility in a Chapter 7 bankruptcy, you have a non-recourse obligation at this point. We'll talk more when we come back after the break because there's way too much
You
and I can't
popped in
finish
a new
it.
word on me there, non-recourse.
Is the debt piling up? Struggling to get by?
It's all about preserving future income. Bankruptcy is one option. When it's right, it's the least costly, most effective way to save your home, eliminate a second mortgage, and wipe out credit card debt. But you need to address the problem now.
We help people with bankruptcy. Call the experts.
We're Thav Gross. Our firm will solve your problem.
888-235-HELP. That's 888-235-HELP. Carrying too much debt? Resolve your debt. Call Thav Gross.
You don't need to be broke, and you don't need to hit rock bottom. If you have income and you're struggling with debt, dump it. Think about the next 10 or 20 years. If you do what the banks tell you, you'll have nothing to retire with. There is a solution.
Don't waste your future. Call Thav Gross. We're experts at eliminating credit card debt. 888-235-HELP. That's 888-235-HELP.
A lifetime of hard work. If you don't have the right plan in place, you can lose your home, your savings, and more. And you didn't come this far to lose everything. Samasco Law wants you to know that laws are changing. Today, the average cost of nursing home care is $85,000 a year. With proper planning, we can help protect your life savings and get you the Medicaid and nursing home benefits you deserve.
How much can you afford to lose? Call Samasco Law today.
If you're retired and in a financial crisis, there is a way out.
It pains me when I see a retired couple exhaust their savings by paying credit card bills and for a home hopelessly underwater.
Thav Gross specializes in helping retired people in financial crisis.
You just can't keep paying until you're broke. You need to address the problem now.
888-235-HELP. That's 888-235-HELP.
We're Thav Gross. Our firm will solve your problem. Brian, we came up to the break. We were talking about the difference between the house and the note, and I get it. The benefit is if you file a Chapter 7 bankruptcy, you discharge your obligation to pay on the note, but you still are subject to the lien on the house, so unless you make the payments, you are going to lose the house. But if you make the payments, you can continue in the house. But you threw in a new word.
Non-recourse.
What does that mean?
Okay. What that means is once you've done the bankruptcy.
Whoa. Repeat that.
Once you've gone through the bankruptcy.
I thought you said once you've done the bankruptcy.
Once you've done the bankruptcy.
Once you have done the bankruptcy.
I'm
sorry. I'm just teasing you.
You lost me there. All right.
Okay.
Anyway, once you've gone through
over the years, you've picked on my inartful use of the English language many times.
Many times.
Yes.
Anyway, once the Chapter 7 bankruptcy has been completed,
much better.
You no longer have a legal obligation to pay the promissory note.
So it's non-recourse?
Therefore, the bank has no ability to come back after you personally. Therefore, they have no recourse, otherwise known as it's the equivalent of
a non-recourse note. It's just a non-recourse circumstance.
Right, but it's the way businesses used to borrow money without having to guarantee the debt. And that was what was called a non-recourse loan. There were no individuals who they could come back after.
Only the property is security.
Correct.
For the loan.
You get what's called in rem relief.
Okay. So the benefit there is you have this situation now. The house is underwater. You owe on the house $110,000. It's worth $75,000 or less. You've discharged your obligation to Bank 2 on the second mortgage, to Bank 1 on the first. So what's the benefit?
Well,
if you want to stay there, you still got to pay, right?
This is true.
So what's the big deal here?
Well, let's assume, for sake of argument, that this house isn't gaining any value. And
it's never going to be worth more than what you owe.
And it's never going to be worth more than what you owe, which means that you can't sell it.
So shouldn't you leave?
Well, no, you want to keep it because you want to live there.
For the reason that you have to look at your alternatives. To move somewhere else and pay rent may cost a lot more, and it may be the biggest. It may be a size of a house that works for you and your kids right now, and it's not time to downsize yet.
So, what you can do to help yourself out after the bankruptcy is the interesting issue. You have the option to go pursue a loan modification. Now, why would you do that? Our goal right here is we know we're never going to be able to pay off this house. In fact, we have a short-term goal of staying here for 4 or 5 more years, but we've got a 30-year mortgage that we've got 27 years left on.
So the loan mod would do what?
The loan modification could stretch that loan payment out over 40 years.
Which would reduce the payment.
Which would substantially lower the payment. Now imagine this. You have a 40-year mortgage. You're 65. You're not going to live to 105 most likely. You're not planning on living there forever,
You're
right?
not paying off the house.
You're never going to pay off the house.
It's cheaper rent.
Right, until you decide to move.
And then what?
Then you shut the door, turn off the lights, turn off the gas, and leave.
Or if you wanted to really, I don't want to say game the system, you could stop paying for the better part of a year and let it go through foreclosure.
And that's because under the foreclosure statutes and Reg X in combination, they can't start a foreclosure in Michigan or in anywhere on your first mortgage unless you're at least 4 months behind. Then they have to publish and do the 5-week publishing. So now you're 5 months behind. Then they go to sale, and you have a 6-month right of redemption. So and
then it takes about 2 months to evict you.
Yes, the very minimum period of time you have to stay in that house is at least 11 months.
Yeah. And if you really want to work the system, because the way Reg X works, if you submit a complete loan modification requests before you're 120 days behind, the lenders are extremely paranoid about complying with Reg X because there's a lot of remedies against the lender and oversight for failing to comply. So when we get a Reg X situation in and we apply for a loan modification, when they say no, we keep appealing it. You could probably add on another 6 to 9 months to that year just by going through the loan modification process when you really don't want a loan modification.
That's right. And if you do it right, it eliminates the ability of the lender to dual track, which means to pursue the loan modification with you at the same time they're pursuing the foreclosure.
One of the biggest benefits of Reg X. So, but is that wrong to do that, Brian?
Absolutely not. I do believe that
see, I don't consider that manipulating the system. I consider that using the system in a smart way.
I want to find that Donald Trump quote again, because
he uses the bankruptcy laws to his advantage.
Yeah, he did, and it's one of those things like
we said. The
bankruptcy laws exist for a good reason. No, scratch it. I keep reading your quote. I take advantage of the laws just like many other very successful people. He used the word very. That's another English faux pas.
Well, I mean, we're not really talking about Donald Trump in this segment, but if you listen to Donald Trump, he uses the word very a tremendous amount. And one of my mentors and friends, David's father, Milton Einstein, cringes when he hears the word very, because it's a weak word when it comes to writing or speaking. So I'm sure that Milton would have words to lecture Donald Trump for in a very significant way.
In a very significant way?
Other options with the house. So you can do a loan modification, and the benefit there is reducing the payment after you've discharged the debt. Now, we also talk about short selling a house, but a short sell in the context of what we're talking about with bankruptcy doesn't really fit.
No, it doesn't work from a practical standpoint in that there's nothing to gain from short selling the house.
If your only debt problem is the house and you're going to short sell it, you don't need a Chapter 7 bankruptcy. They're kind of they're accomplishing the same objective. A short sale gets you out from the obligation on the house, but you have to move when you close the sale. It's a good thing to do sometimes, but it's not the same strategy.
Advantage of doing a short sale while avoiding a bankruptcy is that your eligibility for a new mortgage, if your situation improves so that you can get it, you qualify for a mortgage, otherwise financially,
2 years.
Improves to 2 years. So there is a reason to short sell versus filing a bankruptcy.
Yeah, I want to move off short sale, but I want to make a comment. When the short sale market was hot and a lot of people were short selling in 10 and 11, they were talking about, you'll never be able to buy a house, or it'll be a 5-6 year wait. You know what it turned out to be? It turned out to be a 2-year wait. 2-year wait. You can get yourself a conventional mortgage without much difficulty at all. It just shows when you hear what they say, you need to dissect who they are and what they know. And even if
which is usually very little.
And even if they have credentials, they probably don't have the ability to predict the future. That's what you have to keep in mind. Chapter 13, how does that come into play with a benefit on your house?
Wow, there's so much, but the biggest benefit of Chapter 13 in a situation like this is something we call lien stripping. Lien stripping allows us to eliminate the second mortgage and throw it away.
So you can lien strip that second mortgage, get rid of it, and then if there's equity to be had in the house, you can gain the benefit there.
Absolutely.
Tax problems are major problems. Don't let the IRS levy your wages and seize your assets. There is a solution.
Worth Ave Gross, our firm will solve your problem.
If you're behind on your taxes and owe money to the IRS, call Thav Gross.
We've been solving tax problems for 32 years. We stop wage levies, resolve unfiled returns, and obtain the best possible settlements.
Call Thav Gross today, 888-235-HELP.
A lifetime of hard work. If you're approaching retirement and don't have the right plan in place, you can lose your home, your investments, and your savings. And you didn't come this far to lose everything. Putting a solid strategy in place with Samasco Law legally protects your assets as well as your wishes. Since a will doesn't cover you medically or financially, Samasco Law goes beyond ordinary asset management protection to safeguard everything you have.
How much can you afford to lose? Call Samasco Law today.
If you're retired and in a financial crisis, there is a way out.
It pains me when I see a retired couple exhaust their savings by paying credit card bills and for a home hopelessly underwater.
Thav Gross specializes in helping retired people in financial crisis.
You just can't keep paying until you're broke. You need to address the problem now.
888-235-HELP. That's 888-235-HELP.
Worth Ave Gross. Our firm will solve your problem.
A lifetime of hard work. If you don't have the right plan in place, you can lose your home, your savings, and more. And you didn't come this far to lose everything. Samasco Law wants you to know that laws are changing. Today, the average cost of nursing home care is $85,000 a year. With proper planning, we can help protect your life savings and get you the Medicaid and nursing home benefits you deserve.
How much can you afford to lose? Call Samasco Law today.
Is the debt piling up? Struggling to get by?
It's all about preserving future income. Bankruptcy is one option. When it's right, it's the least costly, most effective way to save your home, eliminate a second mortgage, and wipe out credit card debt. But you need to address the problem now.
We help people with bankruptcy. Call the experts.
Worth Ave Gross. Our firm will solve your problem.
888-235-HELP. That's 888-235-HELP.
All right, welcome back. I want to go into Chapter 7 with Brian, with you, on discharging taxes in a minute. But let me do announcements first. Our office in Flint is up and running. I want to remind listeners to also watch the TV version of Law and Reality. That's Sundays at 11 o'clock a.m. on TV 20. And check out our Law and Reality website. We have a seminar coming up Wednesday, September 30th, Time to Get Serious About Debt Elimination, focusing on all the ways in which you can preserve future income for you and your family and get rid of debt in the fastest, most efficient way possible. It's not just bankruptcy. There's other options to explore. We're going to walk through them. To sign, you also get a free copy of my book, Dump Your Debt. The seminar is 7 to 8:30 p.m. at our offices in Bingham Farms. To sign up, go to lawandreality.com or thavgross.com or call 888-235-HELP. You can also obtain free reports, Pat Samasco's Retiree's Guide to Social Security, my Reg X special report, How to Save Your Home with Regulation X, The Hidden Secrets. Both of those are available for free on the Law and Reality website. I want to thank our sponsors, Thav Gross and Samasco Law. Back to Chapter 7. Discharging taxes in bankruptcy.
Taxes?
Is that possible?
You can discharge taxes in bankruptcy?
I don't know. I'm asking you. You're the person who's supposed to know the answers to these questions.
Well, the problem is that most attorneys out there don't know that you can discharge taxes. Income taxes are dischargeable in bankruptcy. There's some very specific parameters that have to be met.
All right, so income taxes are, payroll taxes are not?
That's correct, because payroll taxes are called a trust fund tax. When you take money and hold it from your employee, you are holding it in trust for the government. You are responsible. The actual employee is the one who's really paid it, and when you don't pay it over, you are responsible not only as a corporation, but individually as an officer of the corporation. You can be held responsible for non-payment of those trust fund taxes.
That's on the portion that was withheld from their taxes.
That's correct.
Not the employer's match.
The employer's match doesn't follow you individually, but the employee's portion does.
Okay, so income taxes, we're talking about your 1040 taxes,
That's
right?
correct.
Okay, which is the dominant tax that
and
people incur.
These rules apply both to the federal income taxes, the state income taxes, and your local municipality if you have a local income tax such as Pontiac or Detroit.
All right, now there's some kind of a rule that you call the 32240 rule. What is that?
Okay. If the tax came due at least 3 years ago, has been filed for at least 2 years, and you haven't been assessed in the last 240 days, the tax is generally dischargeable. There are exceptions to that rule, and we have to look at each case individually. But the first place you start is, did the tax come due 3 years ago? So the last tax return that came due 3 years ago was, for us right now, 2011's tax return, right? The year ending 2011.
That would have been due April 15th, 2012, and now we were beyond April 15th of 2015, but it's not April 15th of 2016. So
correct.
Correct.
But if you filed an extension,
pushes the date out
to October 15th.
Does it push it to October to the date you filed?
It pushes it to October. In other words, your 3 years starts running from October 15th, 2012.
'Cause once you file the extension, it becomes due October 15th.
Yes. So
Gotcha.
we start counting October 16th because you always want to be careful. Then there's a lot of other parameters in there.
But here's one that's
3
important.
years old. Then the tax return had to be filed for at least 2 years.
Back up or just stop on those words. Had to be filed is also an important concept here, isn't it?
It is imperative and that means that you had to, the tax payer had to have a tax return prepared for you or prepared your own, and you had to sign it and you had to submit it to the IRS. And here's what had to happen. You had to do it before the IRS filed a return for you.
And that's called a what?
A substitute for return.
So what's really important here is the benefit of discharging income taxes is a tremendous benefit from the standpoint that we recently had a case where we actually discharged $800,000 of income tax liability on a client, and it had been a long battle on his taxes, and we had to make the process work by making sure that the large amount of tax owed was more than the 3 years old. We marshaled his assets so that we paid the current taxes as best as possible because those were not dischargeable, and then we filed.
You know what was really important about that situation?
If you don't file your own return and the government files for you, it does not work.
It's never dischargeable. A substitute for return or a fraudulent return is never dischargeable. But what's really important about that client that we had with $800,000 worth of tax debt is to know, for you out there listening and watching, you don't have to be broke, truly broke, to get rid of your taxes. In other words, this client happened to still be making a couple $100,000 a year when we filed his Chapter 7 bankruptcy.
But what about the means test?
You know, that's the interesting thing.
Doesn't the means test say if you make too much money, you can't file a Chapter 7?
It does, except there's a big exception to that means test.
Which is?
Non-consumer debt. If the majority, of your debt,
your taxes are a consumer debt.
They are absolutely not a consumer debt.
Isn't that surprising when you think about it?
It is. Income taxes are considered a non-consumer debt, and thus, if the majority of your debts, when you take your mortgage, your car payments, your credit cards, are non-consumer debts, you can discharge them in a Chapter 7 bankruptcy, even if you're making above the median income.
And let me just share with you,
wouldn't pass the means
one of
test.
the fun types of things that Brian and I do. Suppose a client comes in and he has $300,000 of non-consumer debt and $320,000 of consumer debt, consisting of a $270,000 mortgage and $50,000 of credit card debt. In that circumstance, your consumer debt exceeds your non-consumer debt, you can't file. So what do? We've got 1 minute to explain it.
We do debt resolution to bring the credit card debt down just
Underneath.
enough so that our non-consumer debt exceeds our consumer debt. And when that happens, bang, I can file the bankruptcy
We file
and
the
get rid of all of
bankruptcy,
it.
and we discharge all of the debt, consumer and non-consumer. That's a wrap. Enjoy your week. We'll be back next week with Law and Reality.